given the breadth of data protection legislation and the difficulty that some companies find in applying resources to make sure that compliance has been met in all material aspects, it's very easy for small issues to sort of snowball and become more significant for an overall corporate transaction than they really need to be. Just taking a step back for those that aren't aware, two of the main corporate transactions that you'll often see in a business's life cycle and where you'll often be engaging corporate solicitors are investments and acquisitions. Investments are where you have an entity that's receiving funding from an investor in exchange for equity in the company. It's similar to like what you might see on Dragon's Den, where they provide some money for X% of the business. As part of that investment, you might see that an investor will get certain rights, such as an appointment right on the board, or they might have consent matters where you can't do certain things without checking in with them and having their approval first. On the other hand, an acquisition, which is sometimes referred to as an exit, is where a business is sold to a third party. This might be by way of a share sale, where the entire issued share capital is transferred to a buyer who then owns that business. Or an asset sale where certain assets of a business are sold to a buyer. Examples of an asset sale might be a business which has a manufacturing limb and decides to offload that limb to another buyer. So they transfer across the warehouse, factory, other machinery, etc. They carry on running the other elements of their business, and then the warehouse is with a new buyer to operate. You could also see examples where an asset like a customer database is transferred to a new buyer. Regardless really of the corporate transaction that you're dealing with, data protection necessarily is relevant. With investments or exits, investors or buyers are conducting diligence on the proposed target, and they'll essentially be kicking the tires to see that everything's in order before they provide their funds. So that you'll often see that they'll share what's called a due diligence questionnaire, which is a long list of inquiries where they're asking just fact-finding questions, and this will inevitably include data protection queries. And so founders, sellers, etc. are essentially going to need to know their current compliance. They're going to need to respond to very specific queries, and they're going to need to understand whether they've been in breach of any data protection legislation. Whilst that is all ongoing, the main transaction documents would also be negotiated, and those documents will inevitably include warranties whereby the target or the sellers give warranties as to the status of their business. This essentially backs up what's been provided as part of diligence and provides teeth to those responses. So, for example, if as part of diligence you were asked queries on your data protection compliance and you said, yeah, this is all great, we've got perfect compliance, it would be typical to have a warranty that says that all data protection legislation has been materially complied with, and therefore you'd be giving a contractual sort of basis to what you've said as part of diligence. If following the acquisition or the investment, it transpired that maybe data protection compliance hadn't been as great as was originally set out, and this led to a loss in the value of the shares that had been acquired by the investor or the buyer, they could seek to bring a claim for breach of warranty. The buyer or the investor would need to prove the loss that they have suffered, and may also need to demonstrate that they've mitigated that loss. You know, they'd have to prove that they hadn't allowed the data protection breach to become larger than it needed to be. In some instances, therefore, it's quite difficult to prove that that particular data protection warranty breach actually led to a loss in the value of the shares. In other instances, typically where there's a specific issue that's been identified as part of that initial diligence and fact-finding exercise, buyers or investors might look to include indemnities. An indemnity is a promise to that buyer or investor to be reimbursed and results in a pound-for-pound compensation relating to that loss. So if the buyer or the investor ended up incurring a cost of £100,000, for example, fixing a data protection issue that had been indemnified, then regardless of whether the value of the shares had gone up or down as a result of that issue, the sellers or the company giving the indemnity may be on the hook. In case it's not obvious from those examples, generally you'd want to avoid having to give indemnities in any example, as it's a much more punitive example of remedy. Typically, indemnities are more likely to be given in acquisition scenarios where you've got sellers who are often departing the business and they want a clean break, and so the buyer needs to receive an indemnity so that they can sort of make sure that the sellers are on the hook as they ride off into the sunset with their cash. Whereas investment scenarios, indemnities are less common because the investors typically on the board with the founders and the shareholders, and they're looking to work together to ensure compliance. So having an indemnity for a pound-for-pound loss doesn't often sort of sit well with that relationship. And so in practice, looking at sort of all of the transactions and corporate transactions and where data protection sort of plays a role, what we often see is that data protection issues initiate at the sort of diligence stage, and then they necessarily make their way into the warranties and potentially indemnities in the transaction documents. Typically, as I mentioned at the beginning, data protection compliance isn't often very considered in very much detail or dealt with at all. We often see as part of the diligence process that responses to data protection queries sort of say things along the lines of, oh, our company doesn't process any personal data, which all businesses essentially will do. Or they might consider that because you're just selling, a factory or an asset, you don't really sort of consider that data protection is relevant. It's just a transfer of an asset. Other times, people just refer to the fact that they're registered with the ICO and have a data protection officer and then provide no further evidence. What this means is when you do have an example of a poor sort of set of diligence queries in relation to data protection, is that it then encourages an investor or a buyer to have a sort of bulky set of data protection warranties, so to protect their position, because you've given them an indication that this hasn't really been considered, and so they're going to want contractual promises to make sure that they can sort of remedy themselves if they end up suffering a loss. In particular, we see quite a lot of indemnities in this area because it's easy for investors or buyers to identify specific breaches of data protection legislation, such as not having appropriate policies in place, not maintaining an awareness or registers of the processes that are used, or which third-party processes are processing business personal data. It's difficult to refute indemnities in that instance because you've teed them up with diligence responses that say, we're not compliant in these particular areas, and then they're going to ask for indemnities on those, and it's hard to fight back from that position. Practically, therefore, what we encourage sort of target companies to do is at the diligence. So first of all, to sort of ensure that their data protection compliance, they've considered it and they've taken advice on the matter. If at the diligence stage, target entities can demonstrate that they're aware of what they need to do to comply with data protection legislation and show that they put in place appropriate measures, this can benefit them in a number of ways. The first of which is that it reduces the likelihood of that heavy suite of data protection warranties being included in the first draft on which you have to negotiate from. You've shown that you've taken legal advice, and so it's not appropriate to have 4 or 5 pages of data protection warranties and only a few are necessary. Secondly, it also reduces the likelihood that indemnity for a specific issue is requested. You've shown that you've taken the matter seriously, taken professional advice, and therefore it's not appropriate that you offer up that pound-for-pound basis of recovery via an indemnity. And sort of finally, as part of the overall picture, if you can show that you take a matter such as data protection, which is often overlooked, seriously, then it paints a really good picture to the investor or the buyer that other areas of compliance are likely to be in order. That might then give you a stronger negotiating position. So say if there are other areas where you're not compliant, so for example, you don't have an anti-bribery policy or something of that nature, if you can show that in data protection you've taken things seriously, in other areas you've taken legal advice where appropriate, as an overall package, investors and buyers might be sort of willing to overlook other oversights if you're sort of able to paint this beneficial picture of the target that they're acquiring. Obviously, data protection legislation is broad, and it's not necessary to show complete compliance with all elements of data protection legislation as part of that process. But by being able to show that you've taken appropriate consideration and have reasonable measures in place, then it can help to make any corporate transaction a lot smoother. And just is sort of an easy thing for investors or buyers to tick off as they look to progress the transaction, and can avoid things snowballing, like I mentioned at the beginning, and becoming big issues when they don't need to be. So Charlotte is now going to talk in a bit more further detail around transaction compliance with data protection and privacy considerations.
Thanks, Charlie. So transaction compliance, this is the compliance of data protection law in the life cycle of the transaction or the deal, and it's often overlooked by the parties. This will dictate the conduct of the parties and the sharing of personal data during the transaction, and how you manage and ensure that you're processing in compliance with data protection law. So why is data protection compliance relevant in corporate transactions? So it comes up at many different points during the corporate transaction, whether it involves a data-rich business or not. And the principles underpinning the UK GDPR apply throughout the entire timeline of the deal. So it's not just the business compliance aspect that's important, but also the conduct of the parties when processing and sharing that information. As Charlie mentioned, that might be from initial discussion phases and signing of NDAs through to due diligence and completing due diligence questionnaires and disclosure phases, which nearly always include personal data, and in which context the parties would be processing that personal data as part of assessing the company in the overall deal. Also between signature and completion of transaction documents. So for example, on an asset sale, when the transaction completes, if the asset contains personal data, for example, a customer database, that would be transferred as part of the deal, and that would continue to be processed by the business following completion. And then post-completion, you may find there are circumstances where you have things like transitional service agreements, where a seller may support the buyer with a period of transition post-completion. Again, that would involve the sharing of personal data. Or in the sale of a business as a going concern, you would have employees that would transfer across to the buyer under 2P or otherwise, and that employee personal data would also have transferred to them. It's really useful to refer to the ICO's data sharing code of practice, and that does include a specific section on due diligence and M&A transactions. So if this is relevant to you, we would suggest reviewing that as an important starting point. So the types of transactions also have a bearing on the way that data is shared and processed during the transaction itself, as Charlie mentioned. Turning firstly to asset purchases, and this is a scenario where the buyer purchases the assets of the seller. In a data protection context, this could include things like sale of a customer database or a marketing list. Only the assets transferring will go to the buyer. So the buyer would then become the controller of any personal data that's contained within that asset. For e-com businesses, and generally any businesses dealing with consumer customers, it's common for the buyer to purchase the seller's marketing lists with the intent to rely on any consent that the seller collected for the purposes of things like direct marketing. This, of course, attaches a value to the sale and is often part of the sale price. So for data-rich businesses, this can be really key. And one thing I want to talk about is, can the buyer rely on direct marketing consent collected by the seller prior to the sale? Well, the legal framework around this imposes strict requirements, as I'm sure most people are aware, but marketing consent needs to be specific, informed, and any third party relying on that consent must be named at the point at which the consent is collected from the individual. For an asset sale, that doesn't usually, it's not usually possible to name the buyer at that point. It might be that they're unknown, or it might be that it's on a confidential basis. The only way of selling a marketing list compliantly as part of an asset sale would be for the seller to reach out to those on the list and re-permission consent with the buyer named, when that's possible to do so. Whilst this is the approach that's consistent with the UK GDPR, it does pose some fundamental roadblocks in corporate deals. Recommissioning consent can only be possible post-sale, often, as I mentioned, due to confidentiality, but also the buyer can only market to those who then opt back in. So there's a commercial risk to the buyer in that scenario that they've then lost the value in the marketing list that they've already purchased. Where we do see this happen on quite a regular basis, which is why we thought it'd be useful to talk about. And what we do often see is that the parties will choose to take a risk-based approach, where the buyer, for example, might look to re-permission the consent themselves post-completion. That does pose some level of risk, as that initial email would be unsolicited marketing for those purposes, which could lead to things like a loss of consent from data subjects, or in a worst case scenario, breach of data protection law leading to regulatory fines, etc. there are other options that can be considered as well in terms of the overall structure of the deal. So if the marketing lists and those consents hold real value, then it might be that the seller could look to repermission the consent after exchange, but before or completion, and the purchase price could be adjusted accordingly through a clawback mechanism or otherwise. The key takeaway here is that consent does not automatically transfer to the buyer in an asset purchase. So it is something that parties do need to be alive to and tread carefully around, because there is the potential for breaches of data protection law here. In a share purchase, the target shares will transfer to the buyer on completion, and the target will remain the controller in relation to the personal data relating to the target's business. As there's no change in controller, it's possible to argue that there's no strict requirement to provide data subjects with a fair processing notice, because the ongoing use of that data would be the same. That being said, if the data is going to be used for a different purchase by the buyer, then you would need to update that information and to make sure that that information is readily available to those data subjects. As Charlie mentioned, depending on the nature of the transaction and what's being sold, the buyer may also end up acquiring certain liabilities from the seller. And for data-rich businesses, this is where due diligence is really key and really critical. The buyer will need to understand the seller's overall data protection compliance, as Hannah will talk about, and the areas of non-compliance so that they can assess the associated risks and understand what liabilities it's prepared to take on and how that will impact the value of the business. Data protection liabilities are potentially very high, both in terms of regulatory fines, compensation claims by data subjects, and reputationally. So this, again, impacts the warranties and the indemnities that could be given in the transaction documents. And for investment deals, again, Charlie sort of touched on this, but from a data protection perspective, a company's compliance can impact the overall risk attached to that company's trading activities, and then potentially impact the likelihood of securing funding or investing. So it is really worth looking at your overall compliance before going through those investment rounds, so that you can attract as many potential investors as possible. Compliance during negotiations. There are a number of aspects of data protection law that come into M&A and corporate transactions, and this is how the data is shared between the parties. Firstly, looking at NDAs. So this is non-disclosure agreements, a document which most people will be familiar with, but it can be really important in these types of transactions, not to just protect against disclosure of confidential information, but it can also deal with data protection issues that may arise in those early stage discussions. So a good NDA in this context could include things like provisions to return or destroy personal data on termination of discussions or once entered into the transaction documents, clauses to deal with the protection of personal data, things like security measures, what happens in a data breach, communications from data subjects as well. They can also be used in some circumstance to deal with international transfers. And again, this is really important where you have an international or cross-border aspect to the deal. So for example, if you have one or more group companies or advisors that are based outside the UK. Using NDAs is key for best practice, and it's in line with the ICO's data sharing code, but it also sets the expectations of the parties of how data will be used and managed during that transaction. And it also gives the parties contractual recourse in the event that there was something like a data breach. Data rooms, so usually one party will set up a VDR virtual data room where information can be uploaded about the target business. These can contain thousands of documents and will nearly always contain personal data. That would be things like employment contracts, employee information, key contracts with suppliers or customers, mailing lists, etc. You should ensure that there's an appropriate level of security of the personal data, including protections against hacking and otherwise. We would generally expect the encryption methods adopted, access controls, so very basic things like usernames and passwords for those accessing the data room, but also things like watermarks on documents so that documents can't be easily copied, and prohibitions on downloading or printing documents, for example, so that it's not easy for those documents to move outside of the data room. Be mindful of sharing personal data in this way and using data rooms on platforms that are publicly available. So if you have instructed external advisors and lawyers, often they will provide a data room for you. But if you're doing it yourselves and you're looking to use the likes of Dropbox or even emails, make sure that you've read those security policies before doing so. And if you're using free services, be aware that you may not receive the benefit of enhanced security controls, and that should impact your overall risk assessment about sharing that personal data, and really be alive to the fact that you do need to put certain security measures in place. And then Other aspects that are important to consider, which often get overlooked, is can you anonymise data? So this is where information is made available, but it doesn't relate to an identified or identifiable person, and then falls outside of the scope of the UK GDPR. The risk of disclosing personal data in the data rooms can be reduced significantly by using things like anonymising employee data or customer data sets, redacting certain information, even aggregating data. So for example, salary information, you may choose to group salary information so that it's not identifiable to one person, or upload template contracts in the first instance so that you're not attaching actual signed copies. And compiling information and summary information in that way can help to protect against data breaches, and also demonstrates that you are taking you're undertaking technical and organizational measures to protect that data as part of the transaction. Pseudonymization of data is another option as well. So this is editing the data subject's personal information so that it can't identify them unless additional information is added. It still does constitute personal data under the GDPR, and in an M&A context, there's no real practical advantage to doing this over anonymization or redaction. Generally they're sort of all used for the same type of tools, but controllers are being encouraged now to adopt this as a default solution for protecting data as part of their day-to-day course of business. So it might be easier to implement from a practical perspective if it's something you're already doing with the data that you have in the business. Again, this helps to reduce the risk to data subjects and helps to demonstrate that controllers and processors are meeting their data protection obligations, particularly around the principles of integrity and confidentiality. Ultimately, controllers must assess the risk of harm to data subjects. So don't just assume that you can freely share all of your personal data within the company with a buyer or a seller, depending on what side you're on, without a level of protection in place. And this is something that you do need to give due care and attention to during the life cycle of the transaction. I'm now going to pass over to Hannah to discuss sort of wider business compliance.
Great, thanks, Charlotte. So I'm Hannah Pettit and I'm an associate in the Ashford's data protection team, and I'm going to be having a look at businesses' data protection compliance and the importance of this in the context of corporate transactions. So a key part, as Charlie mentioned, of any corporate transaction is going to be the due diligence. And this will involve the investor or the buyer asking legal due diligence inquiries, effectively to get a full picture of the state of play of the business they're going to be either investing in or going to be purchasing. So the first look that they get at your company's data protection compliance is your responses to the inquiries that they raise, and also any supporting documents that you upload to the data room. So that's your kind of real first impression with them. Prior to the corporate transaction kicking off, it's therefore really important to be in a great position where you know what personal data you process, and you know how your processing complies with data protection laws, because if all of that's in order, you're going to be able to give that really good first impression, and it's going to make the due diligence process a lot smoother for both you and also your investors and your buyer. So moving on to the next slide, what I want to have a look at is what are the key compliance requirements that we actually ask about when we're doing that kind of legal due diligence process. So I'm not going to explore all of the requirements on the screen, because what I've done is try to give you a picture there of all of those key topics that we cover in our inquiries. But I'm going to do a bit of a whistle-stop tour of some of the key requirements there. So initial inquiry will always ask is what data does the business process? And this is because we want to understand whether the business is, for example, a really data-heavy business. Perhaps it's consumer facing and processes a lot of higher risk special category data. So a good example being potentially a healthcare app. The risk profile of that kind of business is far different to, say, a business that operates on a B2B basis and only collects and processes low volumes of corporate contact information. So once we've got that clear picture, we'll understand what the risk is of any non-compliance we identify. And also it gives us an indication of actually what your compliance obligations are, because those businesses processing higher volumes of, say, special category data are going to have slightly different compliance obligations compared to those businesses not processing that kind of data. So once we've got that initial picture, that sets the scene for the rest of our inquiries. So another one I want to talk about is ICO registration. So we'll be looking at whether you and your group companies have registered and paid the data protection fee with the ICO. If you haven't, you need to be ready to explain why you've concluded that you're exempt. So then also looking at communications, so complaints or claims. Now, this is anything that alleges non-compliance with data protection legislation that we care about. So we'll be asking, have you received any communications complaints or claims? The reason we ask this is because it gives us an indication of whether there's any risk of you being fined or any risk of you being subject to a compensation claim from a data subject because of a potential breach of data protection legislation. And it's usually a nice, easy one for you guys to answer. It's a question of fact, yes or no, have you received that? Similarly, then, looking at data breaches, we'll be asking whether you've suffered any data breaches. These happen, that's absolutely fine, but we'll then be interested in how you dealt with them. So what assessments did you make? Did you report them to the ICO, to the relevant data subjects? And also, what remedial action did you put in place? So what have you done to prevent that kind of breach happening again? We'll also likely ask for copies of your privacy notices. So a quick point I wanted to flag on that one is around the distinction between internal and external privacy notices. So we'll be looking for not just your external website privacy policy, but also we'll want to see whether you've got an employee-facing, contractor-facing, internal privacy notice as well. So it's making sure that at the outset you're popping all of that in the data room for us to see. And final one that I'm going to cover is just marketing consent information. So reason we really care about this one is it's a key area of focus for the ICO. And it's actually one of the most common reasons that companies are fined for marketing non-compliance. So what we want to know is what basis are you sending marketing on, and we want to see, if you are collecting consent, we want probably to see an example of that consent wording just to satisfy ourselves that you are complying with rules around direct marketing. So this slide provides details of other key areas, which I'm not going into, but hopefully it's useful for you to sort of start looking at that list and think about, are there any gaps here where we know that our current data protection compliance potentially isn't up to scratch, and there are some things on this list that actually you can start thinking about and rectifying preemptively ahead of any potential investment round or exit. So on to the next slide, I just wanted to spend a little bit of time looking at our most common compliance gaps, so the common pitfalls. There's lots more things we see in practice, but these are just a few of the key ones that I thought it would be helpful to cover. So first on the list, we've got group companies and their ICO registrations. So often we see a failure to register all relevant companies within a group. So often you'll see that there's one main trading entity that's been registered and it's all been properly considered, but no one's actually thought about registration requirements for the rest of the group. And it may well be that some of those group companies are non-trading or they may not process any personal data. So it's fine to have concluded that they don't need to register, or they may well process personal data and still be exempt from registering, but you need to have done that assessment for every single entity within your group, and then be able to justify why you consider that any entities that haven't registered don't need to. So second on the list there, we've got processing records. This is just a really common one. When we ask for copies of these, often companies just don't have them. If you've got fewer than 250 employees, you don't have to record all of your processing activities, only certain things. And one of the things you need to record is any processing that's more than occasional. So you are often going to have something that you need to record. And there are freely downloadable templates for these records on the ICO's website, with really easy to use guidance. There's sort of no excuse there not to be downloading those and starting to document your processing activities now, just exactly in readiness for future investment rounds and any potential exits. Final two on the list then, so third-party processors. Often we'll find that companies can't provide us with a list of who their third-party processors are. This is going to include any third party that you engage to process personal data on your behalf. So we're talking about email providers, could be your CRM provider, potentially a HR management tool. But what you do need to do is provide us with a full list of who those entities are. And then depending on the level of the due diligence that we're carrying out, which will depend on the type of transaction and the significance of data protection compliance in the context of your business, Often we will then also ask for a copy of your processing provisions with each of those processes, just so that we can review them and confirm that they're kind of containing everything we expect to see. And then sort of hand in hand with that third-party processor list, we'll also be asking about your location of processing. And often what we'll see is companies will say to us, well, all of our personal data is processed in the UK. But then when they provide us their list of processors, loads of those processors are US based. So it's about being joined up and making sure you have got a really clear picture of where your personal data is being processed so that you can answer that question accurately, and also show us that you've got the safeguards in place to comply with data protection laws. So moving on to the final slide now. I just want to wrap things up by giving a really quick summary of the implications of non-compliance. So ultimately, the risk of really severe non-compliance would be a deal falling through. So an investor choosing to back out, or a purchaser deciding they don't want to go ahead. But this is very, very rare. So in most cases, as Charlie explained at the start, it will actually result in the investor or purchaser pushing for contractual protection within the transaction documents instead. So as Charlie mentioned, that's talking about things such as indemnities within share or asset purchase agreements. So for an example, an indemnity that would cover any losses that the buyer suffers as a result of non-compliance with data protection laws prior to completion. And then in investment rounds, so in the investment documentation, we often see conditions precedent and conditions subsequent. So these are requirements to either rectify something prior to completion or immediately after, so within, say, a set period of 3 months. And it will often be things like within 3 months of completion, we want to see that you've implemented a compliant privacy policy. So, as well as highlighting the consequences of bad data protection compliance, I want to make sure that we're reiterating for you the benefits of actually having good data protection compliance. So, it's going to make the due diligence process quicker and easier for everybody involved. And also, at a time when your senior management are going to be really busy dealing with the transaction, you don't then have to allocate resources to rectifying non-compliance. And also, if buyers aren't going to be asking you for indemnities in, say, your share or asset purchase agreement, this is going to limit you as a seller's your liability exposure. So you want to get things in shape to avoid buyers asking for those indemnities, because you're going to end up with a better sort of liability deal as a result. So there's clear advantages of spending time now getting your data protection compliance up to scratch, and prior to commencing any investment round or any acquisition. So thank you very much for joining us. Sorry that we've run over by a couple of minutes. If you did have any queries, our emails are on the screen there for you, so feel free to reach out. Thank you very much.